Chapter 8. Managerial Judging, Pretrial Conference, and Settlement Promotion. Key Exam Issues. Until recently, pretrial conference and settlement promotion were considered beyond the scope of a first-year course, and they still are more likely to be given intense attention in an advanced course on complex litigation. Nevertheless, they have increasingly been covered in the basic first-year civil procedure course. Moreover, they may play an increasing role in examinations involving challenges to actions by judges that fall outside the traditional realm of judicial activity. In connection with such examination questions, there are two basic questions to be asked. 1. Did the court have authority to take the action it took? Except for inherent authority, a slippery idea, courts must usually ground their right to take non-traditional actions in some statute or court rule. Many jurisdictions allow or require scheduling conferences and orders to set time limits for joining parties, amending pleadings, limiting discovery, etc. Status conferences and final pretrial conferences are also allowed to discuss issue simplification and promote settlement. Courts have also been given some power to use mandatory, non-binding arbitration and summary jury trials to promote settlement without trial. 2. Did the court abuse its discretion? Assuming that there was authority, an appellate court could still reverse on the ground that under the circumstances this authority was abused. The main point to remember is that the court cannot club a party into submission. In addition, examination questions may ask for evaluation of the policy questions that surround the innovations that are discussed in this chapter. Indeed, an examination question may ask the student to evaluate a proposed new program of expediting litigation by comparing it to current practices and considering the arguments for and against adopting the new regime. The main arguments for most procedures are that they streamline cases by simplifying issues and make trial results less uncertain and therefore promote early settlement. The main disadvantages are that the procedures take some control away from the parties over their own cases. Roman II may force important decisions early, before the parties have had a chance to fully investigate issues, and Roman III often force judges to prejudge a case or issue before all the facts are in. A. Pretrial conferences and managerial judging. 1. Historical background. A. Federal Rule 16, 1758. The original Federal Rule 16 authorized a pretrial conference to be held shortly before trial in order to organize the trial. However, concern arose that the relaxed pleading requirements and broadened discovery of the federal rules and the state systems that emulated the federal rules had led to amorphous lawsuits involving excessive discovery expense because they were not focused. In response, and due to rising case load pressures, federal judges in metropolitan districts began, during the 1970s, to experiment with more active pretrial control of litigation. Sometimes this control was handled on a judge-by-judge basis, and sometimes it was implemented by district-wide local rules. This expanded judicial role in the pretrial process was explicitly built into the federal rules, which provide for mandatory conferences among the parties. Fed. R. Civ. P. 26F. Numerous pretrial conferences. Fed. R. Civ. P. 16AC. And a final pretrial conference. Fed. R. Civ. P. 16E. B. State Court Practices 1759. In state courts, such pretrial control was less prominent, in part because in many states, cases were not assigned to a single judge for all purposes. Nevertheless, some added emphasis on pretrial supervision has emerged. See e.g. Cal. Civ. Proc. Code 575-76 regarding pretrial conferences for judicial management. 2. Scheduling 18760. Under Rule 16, federal district court judges have an expanded pretrial role in the control and development of civil cases. A. Mandatory Scheduling Order 18761. Except in categories of cases exempted by local rule, federal district courts are required to enter a scheduling order within 90 days after a defendant's appearance and within 120 days after service of the complaint. This order is to set time limits for joining parties, amending pleadings, completing discovery, and filing motions. Fed. R. Civ. P. 16b. B. Conference 18762. The scheduling order is to be preceded by consultation with the parties by telephone, mail, or other suitable means. C. Other scheduling limitations 18763. Beyond the mandatory scheduling limitations, the court may impose much more specific scheduling requirements regarding a variety of matters as part of its pretrial management of a case. These orders can come at periodic pretrial or status conferences. D. Significance 18764. Limitations on timing of discovery and other matters can be extremely significant to the parties because they can no longer exercise unilateral control over the sequence and timing of pretrial litigation activities. In particular, this control may be especially significant where the parties wish to defer formal litigation activities for some reason, e.g., to discuss settlement. But the court's schedule prevents this. E. Exempted categories of cases 18765. A district court may, by local rule, exempt categories of cases from the scheduling order requirements on the ground that those requirements would be inappropriate in such cases. Fed. R. Civ. P. 16b. 3. Discovery Control 18766. The federal rules affirmatively direct judges to limit discovery if it is cumulative, if the party seeking discovery has had ample opportunity already, or when the discovery sought is unduly burdensome given the needs of the case. Fed. R. Civ. P. 26b2c. A. Conference by parties 18767. At least 14 days before the Rule 16b scheduling conference or order, the parties are to confer regarding the nature and basis of their claims and defenses, and to develop a discovery plan. Fed. R. Civ. P. 26f. Within 10 days after this meeting, they are to submit a written report to the court of their plan. See Official Form 35. 1. Exempted categories of cases. Cases falling in categories exempted from the initial disclosure requirements by Rule 26A1 are also exempt from the conference requirement. Fed. R. Civ. P. 26A1b. 26FC Supra. 1,353 courts may not exempt categories of cases from the initial disclosure requirements by local rule. B. Court's Pretrial Order 1,768. Based on the parties' report under Rule 26F, the court is to enter an order that should limit the time to complete discovery. Fed. R. Civ. P. 16b3a, and may include provisions controlling and scheduling discovery. Fed. R. Civ. P. 16c2f. 1. Criticism. Such precise discovery limitations further impinge on the parties' freedom to control the lawsuit. Moreover, the task of designing such limitations requires the judge to develop a much greater familiarity with the action than would otherwise be necessary, and raises the risk that the judge may misapprehend what is important and therefore worthy of pursuit through discovery. 4. Issue simplification 1,769. At a pretrial or status conference, the court can discuss simplification of the issues and seek to obtain stipulations and admissions of fact to simplify the case. Fed. R. Civ. P. 16c2a. A. Rationale. By the time the matters are raised in the pretrial conference, it is said that the parties know more about their case, and that, therefore, it is fair to pressure them to commit to binding positions for purpose of the litigation. However, there is concern that early pressure toward issue simplification may undermine the supposed benefits of relaxed pleading and unduly constrict cases before the facts are out. B. Compelled admissions 1,770. The court may not compel admissions from an unwilling party, but the court does have the right to pressure parties to abandon positions that seem unsupported. Criticism. Again, The court may not adequately appreciate the circumstances of the case based on the explanation given at the pretrial conference and may unjustifiably curtail legitimate litigation opportunities. 5. Settlement Promotion 18771. It has long been recognized that more active judicial involvement in pretrial activities could have an effect on settlement of cases. But for some time, many judges were reluctant to become overtly involved in settlement discussions, because that might seem to erode their impartiality. This reluctance has waned, and Rule 16c2I now explicitly authorizes discussion of the possibility of settlement. A. Tactics 18772. Judges use a variety of tactics to foster settlement, including meeting separately with each side, requiring attendance of clients at settlement conferences, and meeting with clients outside the presence of their lawyers. B. Mandatory attendance 18773. Rule 16c1 authorizes the court to require that a party or its representative be present or reasonably available by telephone to consider settlement. C. No power to dictate terms of settlement 18774. The court is not authorized to dictate the terms of the settlement. Cothvey, Smith, 771 F2D 667 2D Sir. 1985 Rule 16 was not designed as a means for clubbing the parties or one of them into an involuntary compromise. Nevertheless, the court may suggest terms for a settlement that the parties may follow. D. Ambiguity of judicial role 18775. The judge's role in settlement is hard to square with the traditional notion that the judge decides disputed matters according to standards set out by the law. 1. Evaluation of terms of settlement 18776. It is unclear whether the judge should promote any agreement that seems likely to obtain the consent of the parties, or insist that the agreement correspond, somehow, to the strengths and weaknesses of the merits of the parties' positions. 2. Absence of trial 18777. The judge would usually reach conclusions about the strengths and weaknesses of the parties' positions on the merits only after a trial. To the extent that the judge is to rely on her opinion about the strength of the case in suggesting proper parameters for settlement, involvement in settlement seems to circumvent the normal decision-making process. Example: the weak case for plaintiff. If the case for the plaintiff appears weak, the judge's role becomes difficult to comprehend in traditional terms of decisions according to the law. For example, if the plaintiff has a strong case on liability, but little in the way of provable damages, the judge may be able to suggest a reasonable compromise based on the rules governing damages and her experience with awards in similar cases. However, when the plaintiff's case is weak on liability, it is hard to identify any benchmarks. There is no legal standard or reference point in decided cases for determining the right settlement amount in a case where the plaintiff has a small chance of success on liability, but large provable damages, since the result at trial would essentially be all or nothing for the plaintiff. E. Promotion of alternative dispute resolution 18778. The judge may also explore the use of special procedures, e.g., mini-trials, summary jury trials, mediation, etc., to assist in resolving the dispute during pretrial conferences when authorized by local rule or by statute. Fed. R. Civ. P. 16C2I, the Alternate Dispute Resolution Act of 1998 Infra. 18799 et sec. Directs district courts to adopt some of the same procedures. 6. Final Pretrial Conference. A. Purpose 18779. The final pretrial conference is intended to simplify and streamline the trial and resolve as much as possible before trial. In addition, it serves to give both sides advance notice of the subjects to be covered at trial, so that they can be prepared. B. Required pretrial disclosures 18780. The final pretrial conference will ordinarily follow the pretrial disclosures. At least 30 days before trial, each party is to make further disclosures regarding evidence the party may present at trial. Fed. R. Civ. P. 26A3. 1. Matters to be disclosed 18781. The following types of evidence should be disclosed, except for evidence used solely to impeach witness testimony. A. The names of the witnesses the party expects to present, and those it may call if the need arises. Fed. R. Civ. P. 26A3I. B. The witnesses whose testimony will be presented by deposition. Fed. R. Civ. P. 26A3I. And C. The documents or other exhibits the party expects to offer, or which it may offer if the need arises. Fed. R. Civ. P. 26A3II. 2. Waiver of Objections 18782. As to the indicated exhibits, the other parties must object within 14 days or waive most objections to the admissibility of the exhibits or to the presentation of a witness by deposition in lieu of live testimony. Fed. R. Civ. P. 26A3B. 3. Additional Local Requirements 18783. A number of courts, as a matter of local rule, require more detailed pretrial submissions. C. Topics covered 18784. Local requirements vary, but courts may require delineation of a variety of matters, including the following. 1. Undisputed facts 18785. The parties may be required to list all undisputed facts relevant to the case in pretrial filings. 2. Disputed facts 18786. Similarly, the parties may have to list all facts that need to be resolved at the trial. 3. Witness lists 18787. The parties are usually required to identify all witnesses they will call during their direct cases. See Supra 18781. In some instances, they are required also to provide a summary of the substance of the testimony that each witness will give. A. Direct testimony in writing court trials. Some courts require that in cases to be tried to the court, the entire direct testimony of witnesses be submitted in writing in advance of trial. 4. Legal Issues 18788. The parties are often required to identify and brief all legal issues that are likely to arise in the case. D. Final Pretrial Order 18789. Following the final pretrial conference, the court will usually enter a final pretrial order with regard to the matters covered at the conference. This order is to control the trial and can be modified only to prevent manifest injustice. Fed. R. Civ. P. 16E. 1. Exclusion of evidence and witnesses 18790. The consequence of failure to list a witness or piece of evidence in the pretrial order can, therefore, be that the evidence will not be allowed in at the trial. 2. Distinguish amending pleadings 18791. Ordinarily, the courts take a liberal attitude toward amendment of the pleadings, and it is uncertain how much more restrictive Rule 16 is than Rule 15 dealing with pleading amendments. See Wallen v. Fuller, 476 F2D 124 5th Sir. 1973. It is unlikely that the pretrial order under Rule 16 was intended to make the pleadings, and therefore Rule 15, obsolete. Compare United States v. First National Bank of Circle, 652 F2D 882 9th Sir. 1981. Unless pretrial orders are honored and enforced, the objectives of the pretrial conference will be jeopardized if not entirely nullified. 7. Sanctions 18792. The federal courts have explicit authority to use sanctions to enforce their authority with regard to pretrial supervision of cases. Fed. R. Civ. P. 16F. A. Failure to appear 18793. If a party fails to appear through counsel at a pretrial conference, sanctions may be imposed. In some instances, the court may be able to require that the party appear personally. See Supra 18773. B. appearing substantially unprepared 1794. If a party or lawyer appears, but is not prepared to participate meaningfully in the conference, sanctions are appropriate. C. Failure to participate in good faith 1795. A party can also be sanctioned for failure to participate in good faith. It is unclear whether the determination of good faith can be based on the court's disagreement with the parties' views about proposed settlement terms or stipulations. See Supra, 1774-1777, regarding absence of judicial power to require stipulations or impose terms of settlement. D. Sanctions available 1796. The court can impose the sanctions available for violation of discovery orders Fed. R. Civ. P. 37b2. See Supra, 1634-1662, and also impose expenses, including attorney's fees, resulting from the failure to comply with responsibilities. 8. Effect on work product protection 1797. Information, such as the identity of witnesses and the subject matter of their testimony, would ordinarily be protected work product. Yet courts routinely require revelation of this material as part of the final pretrial process. It has been held that work product protection does not limit the power of the court to require revelation of pertinent information in pretrial preparation under Rule 16. In Re San Juan DuPont Plaza Hotel Fire Litigation, 859 F2D 1007 1st Sir, 1988. B. Court Annexed Settlement Devices. 1. Introduction 1798. Because informal settlement promotion seemed not to exhaust the potential for judicial promotion of settlement, judges began to experiment with other ways of facilitating settlement. Such efforts usually involve some simulation of a trial as a method of predicting the outcome of trial. A. Rationale. A primary rationale for this form of judicial activity is that uncertainty about the outcome of a trial is a major impediment to settlement. Simulated substitutes, therefore, could erase much doubt and give the parties a more reliable format for negotiations. In addition, there are reports that such proceedings enhance litigant satisfaction and permit prompt resolution of cases. B. Initial development at local level. In the federal court system, court annex programs initially developed at the local level as various districts experimented with different methods. The eventual federal statute see below built on and validated these methods. 2. Mandated alternative dispute resolution in federal court, 1799. Under the Alternative Dispute Resolution Adder Act of 1998, district courts are directed to mandate in their local rules that, subject to certain exceptions, litigants in all civil cases consider the use of an alternative dispute resolution process at an appropriate state in the litigation. 28 U.S.C. 652A. The Act further directs that each district devise and implement its own adder program, and that it encourage and promote the use of alternative dispute resolution in its district. 28 U.S.C. 651B. Because these activities occur in connection with cases proceeding in court, and under the auspices of the court, they are often referred to as court-annexed adder. A. Adder Methods 1800. The Act authorizes use of mediation, early neutral evaluation, summary jury trial, and, subject to certain limitations, arbitration. All of these devices will be discussed in detail below. B. Exempted categories of cases 18801. Each district court may exempt categories of cases from the adder requirements. 28 U.S.C. 652b. C. Panel of Neutrals 18802. Each district is to maintain and arrange for the training and evaluation of a panel of neutrals to serve in adder proceedings in the district. 28 U.S.C. 653. A neutral is usually a lawyer experienced in the legal field giving rise to the case. D. Confidentiality 18803. Each district must, by local rule, provide for confidentiality in adder proceedings conducted pursuant to the Act. 28 U.S.C. 652. 3. Mediation 18804. Mediation involves a neutral third party who attempts to find common ground on which the parties can reach an agreement and resolve their dispute. This role is very different from that of a judge or other person who decides a dispute. A. Formal legal rules, not binding 18805. Because the goal is to reach an agreement, the legal rules that might apply in court are not binding in mediation. They may, however, cast a shadow over the mediation and influence the result. B. Creativity in devising solutions 18806. Because formal legal rules limiting court awards do not apply in mediation, the mediator can attempt to devise a solution that would not be available in an action litigated to judgment. C. Goal is agreement of the parties 18807. If the mediator is successful, the parties will reach an agreement that should be embodied in a contract between them. These agreements are usually legally binding in accordance with principles of contract law. D. Separate meetings with parties 18808. Mediators may often find it helpful to meet separately with the contending parties to try to develop solutions that warrant discussion. Separate meetings are permitted. E. Mediation in state courts 18809. Mediation occurs in connection with state court actions, as well as in federal court cases. In some states, there are statutory provisions authorizing court-annexed mediation. See Cal. Civ. Proc. Code 18775 18775-15. 4. Early Neutral Evaluation 18810. Early neutral evaluation originated in the United States District Court for the Northern District of California, and it relies on an experienced neutral lawyer, the neutral, to advise the parties on their prospects in the case after both sides have presented their positions. The parties get the advantage of an early, frank, and thoughtful assessment of their positions. A. Experienced lawyer 18811. The neutral should be a lawyer with substantial experience in the field of law that gave rise to the suit. B. Evaluative orientation 18812. The neutral is to bring a critical eye to the positions of the parties and offer them her assessment of the likely success of those positions. The goal is that this third-party assessment will encourage the parties to be realistic about their chances of success. This effort may include an indication by the neutral of her expectation of an award in the case. C. Occurs early in case 18813. As suggested by the title of this adder device, early neutral evaluation should occur early in the case and before the parties have expended substantial resources on litigation. D. Suggestions for future conduct of case 18814. Beyond assessing the likely outcome of the case, the neutral may offer the parties suggestions about the future conduct of the case to prepare it for trial, should it not settle. These suggestions are conveyed only to the parties and are not conveyed to the court. 5. Summary Jury Trial 18815. The Summary Jury Trial (SJT) was invented in 1980 by a federal district judge in Cleveland. A. Timing 18816. The SJT is normally deferred until all normal pretrial activities have been completed. All motions in limine, i.e., motions seeking a protective order against prejudicial questions and other similar pretrial matters, should be disposed of and a final pretrial order entered. B. Nature of hearing 18817. The specifics on summary jury trials may vary from place to place, but generally they have similar procedures. 1. In courthouse 18818. The proceedings occur in the courthouse, in a regular courtroom, with a judge or magistrate presiding. 2. Before jury 18819. The case is presented to a jury summoned to appear in the normal manner for juries. 3. Lawyer presentations 18820. The bulk of the case is based on summaries by the lawyers of the evidence developed in the pretrial phase. A. Limitations on content 18821. Some guidelines will apply to limit the content of the summaries. The presentations may have to be based on material developed during discovery, or upon the attorney's representation that she has talked to the witness and that the witness would testify as described. B. Live testimony 18822. In some courts, limited live testimony may be allowed. 4. Instructions by Court 18823. After the lawyers have completed their summaries, the court gives the jury abbreviated instructions on the law applicable to the case. 5. Verdict 18824. The jury is to render a consensus verdict, if possible, and if not, to report on reactions to the case on a juror-by-juror basis. 6. Effort to settle 18825. With the added information provided by the jury verdict, the parties try to settle the case. C. Secrecy 18826. Generally, the SJT is held in secret, and the public is not allowed to attend. Example: in a suit claiming that builders of a nuclear power plant were liable for poor design because the facility leaked radioactive steam, a newspaper was denied access to the SJT on the ground that it was merely a settlement procedure. Cincinnati Gas and Electric Co. v. General Electric Co. 854 F2D 906 Sir. 1988. D. Binding effect 18827. In some instances, the parties can stipulate that the summary jury trial will be binding. E. Compulsory participation 18828. There has been a split among the courts on whether an unwilling party can be compelled to participate in an SJT before being afforded an opportunity to have a regular trial in court. Compare Strandell v. Jackson County, 838 F2D 884 7th Sir. 1987 No power to compel. Within Re-Atlantic Pipe Corp. 304 F3D 135 1st Sir. 22 Court has inherent power to order mediation, but must set limits on duration and cost. 6. Court Annexed Arbitration 18829. In the late 1970s, federal courts in some districts began experimenting with mandatory, non-binding arbitration in some cases. In 1988, Congress expressly sanctioned these experiments in 10 districts where such experiments had begun and authorized further experiments in 10 other districts. 28 U.S.C. 651 et seq. This authorization was further extended until Congress included arbitration in the 1998 Act. Subject to certain limitations, states have authorized similar procedures in their courts. See, e.g., Cal. Civ. Proc. Code 1814110 et seq. A. Cases affected. 1. Federal Court 18830. With the consent of the parties, a federal court may allow the referral for non-binding arbitration of any civil action before it except cases involving civil rights claims, alleged violations of constitutional rights, or damages relief sought in an amount exceeding $150,000. 28 U.S.C. 654A. A. Safeguards on giving of consent 18831. District courts that authorize arbitration as an adder device are required to adopt safeguards, e.g., that the district court judge be informed of the identity of who consented to ensure that parties who are asked to consent do so freely and knowingly. 28 U.S.C. 654b. B. Presumption regarding damages sought 18832. Unless counsel certifies that more than $150,000 is involved, the court may presume that damages do not exceed that amount. 28 U.S.C. 654c. 2. State Courts 18833. In state courts where arbitration is authorized, eligibility may turn on the amount claimed, as in federal courts. In California Superior Court, for example, all civil actions where the amount in controversy in the opinion of the court will not exceed $50 are subject to arbitration. Cal. Civ. Proc. Code 14111A. A. Dispute about amount claimed 18834. Under the California approach, there can be disputes about whether over $50 is really in controversy. See Cal. Civ. Proc. Code 1G1 on 4116, a conference to be held to determine whether over $50,000 is actually in controversy. B. Equitable relief 18835. In California, arbitration may not be compelled if equitable relief is sought, unless the prayer for equitable relief is frivolous. Cal. Civ. Proc. Code 14113. B. Timing 18836. Arbitration generally occurs early in the litigation process. C. Hearing 18837. The arbitration decision is based on a hearing, which resembles a trial, but may be more relaxed. The rules of evidence might not be applied with full force, and relaxed rules about the form of presentation of evidence, e.g., narrative answers, may be allowed. 1. Subpoena for witnesses 18838. Subpoenas under Federal Rule 45 are available to compel attendance of witnesses and production of documentary evidence for arbitration hearings. 28 U.S.C. 656. 2. Oaths of witnesses 18839. Arbitrators may administer oaths and affirmations. 28 U.S.C. 655A2. D. Award 18840. After the hearing, the arbitrator is to enter an award, which briefly identifies the prevailing party and, if necessary, the amount of damages. This award is filed in court and becomes the judgment of the court unless a trial de novo is demanded. 28 U.S.C. 657A, Cal. Civ. Proc. Code 1N14120. E. Trial de novo 18841. On timely demand, any party may insist that the case be restored to the regular trial calendar for trial de novo, which is conducted as a regular trial, unaffected by the arbitration proceedings. 28 U.S.C. 657C, Cal. Civ. Proc. Code 1N14120. 1. Less favorable result. In some jurisdictions, if the party who demands a trial de novo does not obtain a more favorable result in the trial de novo, it can be required to reimburse the opposing party for certain costs. Cal. Civ. Proc. Code 1N14121. F. Refusal to participate 1D842. If a party refuses to participate in the arbitration or fails to participate in good faith, the court may have authority to deny a trial de novo. Compare New England Merchants National Bank v. Hughes, 556 F. Sup. 712 ed. Pa. 1983 trial de novo denied. With Lyons v. Wickhorst, 42 Cal. 3D 911 1986, no authority to deny trial de novo under California statute.